Now I'll come back to the Article 129 that I said the court of record. So when this power of contempt was being conferred on the Supreme Court and the High Courts, many members in the Constituent Assembly, they opposed it, and they said that these powers will be misused by the court, especially when contempt of court was placed under the category of reasonable restrictions on the right to freedom of speech and expression. So there was much voices raised against it, but Dr. B.R. Ambedkar supported the contempt powers on the technical ground. He said that Supreme Court is court of record, and court of record has inherent powers, accompanying powers, to punish for contempt of itself. So the court of record, how he defined is, he said that the court of record is the court, the records of which are admitted to be of evidentiary value, and they are not to be questioned when they are produced before any court. So he said that they are of evidentiary value and they are not to be questioned when they are produced before any court. Now when we think of the definition in court of record, usually even we, the law students, confuse this with the concept of stare decisis, the doctrine of precedent, because in courts we cite the cases of the superior courts, the judgments, and they are followed, they are not questioned. So we believe this is one concept. That's not the case. Stare decisis and court of record, they are two different concepts. Though the 1 to 9 has a part, because 1 to 9, when we say the court of record is the proceedings whereof are recorded, and judgment is also part of the proceedings, but it is not the written, it is the oral proceedings of the court that are recorded in court of record. But when we come to the stare decisis, it is provided under Article 141 of the Constitution of India, which says the law declared by the Supreme Court shall be binding on all courts within the territory of India. So law declared by the courts. Now which law? This is the principle of stare decisis, that means stand by the decision or uphold the decision of the court. Each judgment is divided into two parts. It is the ratio decidendi and the obiter dictum. Ratio decidendi is the rationale, the reason for the judgment. It is this part that is that has the value of precedent, that is to be implemented, that is to be followed by the subordinate courts. But the obiter dictum, that is the opinion of the court. While passing a judgment, judge makes many other comments also. The opinion does not have the binding force. So this is Article 141. But when we go to the court of record, how it is defined is that the court of record is a trial court or an appellate court, the oral proceedings whereof are recorded, they are captured and preserved by the court clerk or the court reporter, they are officers of the court, for the possibility of appeal. So what was the rationale? First thing is why the court is made a court of record. The rationale is that a criminal penalty or the contempt penalty should not be imposed unless there is right of appeal. And right of appeal becomes meaningful only if the court, the lower court, the trial court, it maintains a record of the proceedings and a copy, a certified copy of the proceedings is provided to the person who wants to appeal against the order. Now, these, in many democratic countries, the statutes provide a period, a longer period, longer duration for which these records, the evidence and other, because the written pleadings, they are limited in the plaint or a petition. It's very limited part that is put in black and white. Rest all is in the court. It is the cases are cited. There are arguments. There are counter arguments. So there is lot. There is evidence. So there is lot. That is all that goes on orally in the court. So that is required to be recorded, preserved till the party exhausts all its rights to appeal, revision, review, whatever is available to him. Now, with due respects, what I want to submit is that our courts, though they enjoy the power of contempt, but technically, practically, they are not the courts of record. They are rather act like the courts of no record, because the oral proceedings are not recorded at all. There is no such system of recording the oral proceedings. Less to speak of recording the proceedings, even very few honorable judges keep the notes of the oral proceedings, the arguments, the cases that might be cited by the parties. There is a lot. And what happens is, like in the High Court, a bench would hear the matter for 2 or 3 hearings that run into months. Thereafter, the roster changes, and what happens is the matter would be placed before another bench. Now, another bench starts from the scratch, and they would say, I don't know what you have pleaded before the other bench. So, afresh, it's like taking up a case de novo. So what happens is, all the efforts of the advocates, that goes waste, and the precious time of the court is wasted. And this is one of the reasons for delay, because the matter cannot be decided. Roster changes, again it is taken afresh, again roster changes, again it is taken afresh. Sometimes bench would go back to the preliminary issues, which are settled. Thereafter only you move further into the proceedings. So, it would be requested that when courts are enjoying the power of contempt, this power is based on the duty to record the proceedings, to act like the court of record. So that should be done in the interest of justice and for speedy disposal of cases and for transparency and for doing complete justice to the litigants and to the advocates who are pleading. And now I have heard that many must have read that the Supreme Court has, it was before Corona that the Supreme Court had decided to live stream the proceedings of the Supreme Court. So there is nothing like that, and we have the technology. We can now, through CCTV cameras and others, we can record the proceedings of the court, and then they will put into black and white. So it's very necessary that courts act like courts of record. They record their proceedings, and contempt of court, I'll analyze it in my next video. But I believe if it is used sparingly and discreetly. Every institution needs the power of contempt, as our parliament has the privileges to punish for contempt of the House. Similarly, a court also needs such powers to maintain its dignity and decorum. And I tell you, if you visit any High Court or Supreme Court, I have not visited, judges maintain a decorum. They maintain discipline in the court, and it's a pleasure just sitting in the court and watching the proceedings. So for that purpose, I think, and for ensuring discipline and ensuring the obedience of its judgments and orders, courts need contempt, but I will be analyzing it in my next video. I hope you like and watch that video also. So thank you.